Okay, so we've covered the eligibility and coverage issues generally. Now we get into sort of the real meat of what FMLA leave is. While the eligibility conditions are one consideration, the next factor once someone is eligible is whether they have a qualifying reason to take FMLA leave. Most of these are well known to most of you, probably, and to most people in the United States at this point who have been in the workforce, I would say, or at least who've worked for companies large enough to be subject to the FMLA. But there are plenty of details that can create complications in specific situations. Generally speaking, the birth or to care for a newborn child or placement of a child for adoption or foster care are pretty well known to be covered reasons for taking FMLA leave. Most of the other scenarios relate to someone's medical situation. So an employee can take FMLA leave to care for the employee's spouse, child, or parent with a serious health condition, or in the case that a serious health condition makes the employee personally unable to perform the functions of their job. There are two other categories that qualify for this leave that are newer. They have not been around since 1993. They relate to military service in different ways. One form is this qualifying exigency leave, and that's just the term used in the law, a qualifying exigency arising from the employee's spouse, child, or parent serving as a military member on covered active duty or call to active duty status. We'll briefly go over what that actually might mean. And the other form of leave is for the employee caring for a covered military service member who is their spouse, child, parent, or to whom they are the next of kin with a serious injury or illness. I will note right now, and I'll reiterate it in just a couple of minutes, that there are two different medical condition terms in play under the FMLA. One is the serious health condition, and this is for the traditional forms of leave that don't necessarily have anything to do with military service. And then the separate form of leave for this service member, military caregiver, as it's also referred to, leave, where the term serious injury or illness has been added. They are defined differently, and my main note on that at this point is just if, for example, you're applying the FMLA and you get to looking up some of the details of this somewhere, whether it be in the regulations or where have you, be careful that you don't accidentally apply the serious injury or illness standards when you should be applying the serious health condition standards or vice versa.